Does child support cover school fees and extracurricular activities in Utah? One of the most common sources of conflict between co-parents is not just custody exchanges, holidays, or monthly child support payment. It is the steady stream of extra expenses connected to a child's school, sports, lessons, clubs, and activities. Soccer fees, dance costumes, school supplies, club dues, instruments, field trips, uniforms, camps, travel tournaments, private coaching. These costs add up quickly. The problem is that many parents assume child support works like this. Base child support covers groceries, shoes, part of the mortgage or rent, while everything else gets split separately. That is not the law in Utah. Base child support is not merely a grocery payment. It is the presumptive contribution toward the ordinary costs of raising a child. Ordinary school and activity expenses are generally presumed to be included in regular child support unless the parents agree otherwise, the court order provides otherwise, or the court makes proper findings supporting an additional obligation. Utah law separately addresses medical insurance, uninsured medical and dental expenses, and work-related child care. Those categories are different because the statutes treat them differently. But ordinary school fees, extracurricular activities, sports, clubs, lessons, and similar expenses are not automatically separate add-ons to base child support. In plain English, child support is not base support plus half of everything else. Parents often confuse two separate questions. First, is the expense reasonable or good for the child? Second, is the other parent legally required to reimburse part of it in addition to paying child support? Those are not the same question. A soccer fee may be reasonable, music lessons may be good for a child, a school club may be worthwhile, but that does not automatically make the expense separately reimbursable. A parent seeking reimbursement usually needs one of three things: a written agreement, clear order language, or a court order supported by proper findings. Without one of those, ordinary school and activity expenses generally fall within regular child support. This becomes especially important when one parent signs the child up first and asks for money later. That is risky, especially if the activity is optional, expensive, interferes with parent time, or was never discussed in advance. A $40 school fee, $150 recreation league registration, and $6,000 travel team season are not the same practical problem. The solution is not guesswork, it is clear drafting. A good parenting plan should say which expenses are shared, whether advance written approval is required, how costs are divided, and what proof of payment is needed, when reimbursement is due, and how parent time conflicts will be handled. There is also an important caveat in joint physical custody cases. Utah law recognizes that parents contribute to the expenses of the child in addition to paying child support. That does not mean every expense is automatically reimbursable, but it does give courts some room to require shared contribution when the facts and order support it. The practical rule is simple. Do not rely on assumptions. Put the expense rules in writing before the fight starts. Okay.